Hi, everyone. I'm Hillary Bricken, a partner in our food systems group here at Husch Blackwell. I advise clients on cannabis, healthcare, life sciences, regulatory compliance, governance matters, and their other corporate needs. Before we begin today's webinar, I want to cover a few housekeeping items. At the top of your audience console, there are multiple application icons for you to use during today's program. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, we will try our best to answer it via email, but we cannot guarantee responses. A PDF of the presentation is available in the program materials folder, and this program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU sign-in icon at the top of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for our housekeeping items, so let's get started with our program. Today, for the lunch hour, we are going to be discussing cannabis, customs, and tariffs in the United States. I, Hillary Bricken, will be moderating this panel. I'm going to go off camera while our presenters speak, and then I'll come back at the end to do some questions and discussions. So joining me today is Maushami Joshi and Bob Stang. Maushami is senior counsel in our international trade group. She joined Husch's DC office back in 2025, earlier this year. She has represented foreign governments and multinational corporations in all aspects of customs and tariff-related matters. She's represented clients in safeguard, anti-dumping, and countervailing duty actions before the Department of Commerce and U.S. International Trade Commission, and in appeals before the Court of International Trade and the Court of Appeals for the Federal Circuit, as well as before NAFTA and USMCA panels. Maushami regularly advises clients on tariffs and customs rules, including Section 301 and 232 tariffs and exclusion processes, customs classifications, country of origin marking requirements, prior disclosures, relief petitions, and protests. She's especially knowledgeable about Buy America and Made in USA rules and their implications for clients in various industries. Bob is a partner in our international trade group. He focuses his practice on customs and international trade law. He brings more than 30 years of experience to a wide range of issues that affect inbound and outbound goods, including tariff classification, valuation, country of origin marking matters, free trade agreements, and special trade programs. He also has extensive customs compliance experience and regularly assists importers facing U.S. Customs and Border Protection audits, penalties, seizures, redelivery notices, and other agency enforcement activities. Bob works with importers and exporters proactively to achieve cost savings and structure programs that meet CBP's reasonable care requirements. He also handles supply chain security issues, including customs trade partnership against terrorism, the CET PAT enrollment, verification, and annual reviews. Now, on today's program, we're obviously going to be addressing U.S. customs requirements and tariffs as it relates to the U.S. cannabis industry. And just to give a brief primer before we begin, obviously cannabis is still considered a Schedule I controlled substance under the Controlled Substances Act. It is federally illegal. Hemp is a different story. We are not necessarily discussing hemp today. And while there is some talk of reform on the horizon, like rescheduling or maybe even some form of legalization, we are certainly not there yet. And until that occurs, federal illegality is the status quo, and that is always surrounding these other issues of law. So without further ado, I'd like to pass it to Bob Stang to give his an evaluation of what's happening on the customs side, and followed by Maushami, who will talk about tariffs, and then I will see you guys at the end for questions. Thanks.
Thank you, Hillary. So let's just jump right in and talk about the landscape, the statute that we're going to talk about, 21 U.S.C. 863. That's the drug paraphernalia statute. That 863A3 makes it illegal to import or export drug paraphernalia. 863B talks about penalties. 863C, seizure and forfeiture. They define what drug paraphernalia is in subsection D. It's a very broad definition: any equipment, product, or material of any kind, primarily intended or designed for use in a wide variety of activities. And now we get to the important part, which is 863F, and that's the exemption that we're going to be talking about. And the exemption is a broad exemption. You'll notice three important points here. it applies to any person. It is not limited to importers or to manufacturers or to people possessing any person. Second, it covers any kind of law, any kind of local, state, or federal law. And that "or" you'll see is very important. Any one of those will qualify. And last, it applies to what they call, quote, "such items," and you'll see why that has become an important part of this. So if we go back in time a bit, let's go back to 2017, and we have a customs ruling, a ruling from Customs headquarters up here. In this ruling, Customs looked at that exemption in 863F and concluded that that exemption did not apply to drug paraphernalia imported into a state where it was specifically identified as being legal. And Customs, they relied on three provisions. First, they said that based on the plain language of the exclusion. Second, they talked about the importance of avoiding an absurd result. And third, the doctrine of federal supremacy, meaning that whatever the federal government says is going to trump what a state or a local court says. And they said in the context of 863, the generic term items does not mean or include drug paraphernalia. Okay, so even though you had that exclusion in there, that exemption in there, they said, well, that exemption in there that talked about, quote, "such items," they said, well, such items, that doesn't involve drug paraphernalia, even though Section 863 is specific to drug paraphernalia. Another ruling that they issued, now we're up to 2020, and they said that their analysis and their conclusion was based on two tests. The first test being the, quote, "primarily intended for use" test. Under that test, Customs would consider the stated purpose of multi-use articles. Okay, and the second test that they talked about was the, quote, "designed for use" test. And in the designed for use test, they looked at whether it was, quote, "principally used" with illegal drugs. So to take a really out of their example, if you if you import a bong and you use that bong as a flower vase, it's still a bong, it's still drug paraphernalia, even though you're using it as a flower vase. So what happened? Well, what happened was that in 2022, under the Tariffs case, Tariffs, the company, first of all, they imported certain machinery into the state of Washington. And it was agricultural machinery designed to separate the leaf of the marijuana, the cannabis flower, from other plant material. And Washington state had specifically passed a statute that held that it was not unlawful. In other words, it was illegal to deliver, possess, manufacture marijuana-related drug paraphernalia. Customs issued a request for information to the company. The company responded. They said, hey, this is not drug paraphernalia because, number one, it's for hemp, but even if it is drug paraphernalia, you have that exemption in 863F. Customs excluded the goods. Tariffs filed a protest. The protest was ultimately denied, and they went to court. And in the court held, the court basically exercised what we think was common sense. I mean, if you go back to the plain language, okay, and the court said, well, you know, that exemption in 863F, all you need is one relevant legislative body. So that means if it's an exemption, if it's local, state, or federal, that's good enough. And you only need it to cover one of the enumerated activities, manufacturing, possession, or distribution. And if you have one relevant provision by local, state, or federal authorities, and it's covering one of those, then you're exempt from everything in 863F. And the Tariffs case was followed 1 month later by the Kirton USA case. And in Kirton USA, very similar types of facts. They imported certain machinery into the state of Washington. It went to the Court of International Trade, and the Court of International Trade, relying on a Supreme Court case, among others, the Murphy case, they noted that the phrase, quote, any person authorized in 863 F1, that's the exclusion, it extends to all persons affected by the state prohibition, and the Court of International Trade held that it was lawful for them to possess and import their merchandise in the state of Washington. And once again, they relied on the plain language of the Washington Revised Code and 863F, which we think basically brought the courts, it brought the law into compliance with where it should be. So what's been the effect of all this? Well, a couple of things. First of all, Customs has accepted the Tariffs Technologies and Curtin USA cases, and then we're saying mostly, okay? And what we mean by mostly is there's any number of Customs rulings out there where Customs has looked at drug paraphernalia, and we've listed a number of these rulings here, and they have basically acknowledged that based on the Tariffs case and the Curtin USA case, that these goods are covered by the exemption and they're allowed into the United States. However, they have not given up the ghost entirely. In the first ruling that we have here, and you'll notice the dates of these rulings, the first one is from April of 25, so, fairly recent. They say, you state that this product will be imported through the Port of Seattle, Washington, et cetera, et cetera. And it says the holdings in Tariffs and Curtin apply only to importations through a port in the state of Washington. So even though the state of California has similar legislation, okay, they're not totally giving it up, okay? And then we have the second ruling, which is also from April of 25 here. And in that one, in that ruling, you can see, they say that we recommend that admissibility be confirmed prior to importing, basically by obtaining a ruling. And we'll talk about that in a little bit, but basically you can get a ruling from U.S. Customs. You have to go to Customs headquarters. If you do that, you really have to make sure that you're providing all of the information as specifically as possible, including the state statutory exemptions. Interestingly enough, very recently, Customs barred two officers of Tariffs Technologies from coming into the United States from Canada. And Tariffs Technologies actually went back to the court. They went back to the Court of International Trade, and they asked for an expedited decision, and the court denied that, and that was very recently, March 26th of 2025, and the court stated, the allegation was that Customs, CBP, Customs and Border Protection, has unlawfully invoked federal prohibitions to bar two of plaintiffs' Canadian corporate officers, that's Tariffs Technologies officers, and basically the court did not agree. So those folks, they were not permitted to enter. I think one was actually ultimately granted a visa, but not for the other. And we'll see how the court comes out in that case, although we expect it will be the same as the first Tariffs case. So what do you do? Because we know that Customs is still issuing notices of action and requests for information. There's a number of things that you can do if your goods are detained or seized, or you get a notice of proposed action or action taken. What you should do is to make sure that you provide Customs not only with the Tariffs and Curtin cases and the case law, whatnot, but that you provide the exact state statutory or local statutory authorization, and that you tie it very clearly to your goods coming into the United States. And our experience is that if you do that, that it will take customs a few months to review the information, but ultimately it should get the goods released. You can also file a protest with customs against denial, against an exclusion. And once again, you can also file a ruling on admissibility. So those are several things that you can do if you find that your goods are covered, are detained or seized or excluded for one reason or another. So with that, I'm going to turn it over to my colleague. And Moushami, if you would, you're going to talk on the tariffs. And I know that's going to be a very interesting topic to a lot of folks.
Thanks, Bob, and good afternoon to everyone. So let's pivot a little bit to talking about what happens once you know that you're going to import an item into the United States and you're wondering what taxes or duties are owed on that product. Now, previously, when I say previously, I mean before 2018, if you wanted to import a product into the United States, all you had to do was look at the US tariff code, find your, the relevant tariff item, see if there were duties, that were leviable. You would also check to see if there was any anti-dumping or countervailing duty on that product. And if there was, you would pay those duties and clear those goods as the importer of record. That situation has changed quite a bit since 2018. It's gotten far more complicated. Starting in his first term, President Trump imposed a number of different tariffs, starting with Section 301 tariffs focused on China. He then imposed tariffs on steel and aluminum under something called Section 232. All of those tariffs, in fact, were kept in place by the Biden administration. And the Biden administration, in some instances, actually expanded those tariffs and for the 301, granted limited time-bound exclusions. But overall, the scheme of the tariffs stayed in place. In his second term, President Trump has leaned even more into tariffs and has imposed tariffs under a number of new authorities. And the situation is complicated and evolving because, one, there is no end date to these tariffs. And there is a possibility that you could have more tariffs imposed in the coming months, including on copper, timber, pharmaceuticals, and semiconductors, as well as on foreign flag ships. So while previously you'd had to just look at your particular item and look to see, what the tariff was and just see whether there was an anti-dumping or countervailing duty, now if you're bringing in an item and depending on where you're bringing it from, you're potentially liable for at least 3 or 4 different kinds of tariffs, depending on the country of origin of your product. So let's look at what these different tariff authorities are and what they cover. Starting with the IEEPA. IEEPA stands for the International Economic Emergency Powers Act. It's an old statute, was enacted in 1977. And it's the first time that the statute has been used to levy wide-ranging tariffs of the kind that President Trump has in his second term. He had actually threatened to impose tariffs on Mexico under IEEPA in his first term, but that never happened. In his second term, he has used IEEPA authority to impose tariffs on Canada, Mexico, and China by declaring a national emergency. The emergency was to deal with the flow of illicit drugs, fentanyl, as well as immigration from our northern and southern borders, as well as from China. These tariffs were announced in February 2025. They were imposed on March 4th. And the tariffs imposed 25% duties on goods from Canada and Mexico. These are goods that do not qualify under the USMCA. The USMCA, as most of you know, is the free trade agreement between the United States, Canada, and Mexico, which has its own very specific rules for goods traded between the countries. So if your good doesn't qualify under that agreement, a product coming in from either Canada or Mexico is subject to 25% tariffs. There are 10% tariffs under IEEPA on energy resources, and potash from Canada, and 20% tariffs on Chinese products. President Trump has also relied on the IEEPA to impose far-reaching tariffs on all of our trading partners. These tariffs, which are also called IEEPA reciprocal tariffs, were imposed to deal with a second emergency that President Trump declared, and that was related to the United States' persistent trade deficit. The argument is that the United States purchases more from certain countries and it sells to these countries, as a result of which there's a trade deficit, which isn't good for the United States' economy. And the way to correct it is through the imposition of tariffs. So on April 2, which some of you might remember was labeled as Liberation Day, President Trump imposed far-reaching and wide-ranging tariffs on all of our trading partners. The tariffs were staggered in that they first imposed a baseline 10% tariffs on all countries except Canada and Mexico. On April 9, President Trump announced the Liberation Day tariffs were to go into effect on April 9 for specific countries that had higher or individualized higher rate. So for instance, the rate for Cambodia was, I believe, 46%. For China, it was 34%. For India, it was 26%. For Malaysia, it was 24%. And for EU, it was 20%. Although those tariffs were to go into effect on April 9, on April 10th, those individualized country-specific IEEPA reciprocal tariffs were paused, or they were suspended until July 9, 2025. And the rates were brought down to the baseline rate of 10%. The idea here is that the countries that are subject to these higher specific tariffs will negotiate trade deals with the United States. And if they do so, their individual rates may be reduced. And so at this point, as you may have heard in the news, there are a number of countries that are negotiating deals with the USTR in the hopes that after July 9th, those high individual rates will not be implemented against those countries. We are awaiting to hear how those negotiations are going and if they've been successful. So far, we only know about the negotiations with the UK, which I'll come to when we speak about the 232 tariffs. But at this point, those negotiations are ongoing. So China is a little bit of a separate, distinct case. As I mentioned, the original rate, the individual rate for China was set at 34%. And China immediately retaliated against the United States. In response to that retaliation, President Trump increased China's rate again to over 80%. China retaliated again, and the United States retaliated back with a rate for China at 125%, which was prohibitive. China then imposed a number of export restrictions, including on critical minerals, which are very important to a number of industries in the United States. As a result of the escalating trade war, the two countries decided to, and realizing that wasn't helpful, the two countries decided to come to the negotiating table and talk through how they might want to de-escalate that situation. So on May 14th, the Trump administration agreed to reduce China's reciprocal rate down to 10% for a period of 90 days, which expires on August 12th. Again, the idea is that China and the United States will reach a trade deal by that date for that rate to continue. If not, there's a possibility that the rate for China may increase again. At this time, there is legal uncertainty about the fate of these tariffs. These tariffs have been challenged by a number of small businesses as well as state attorneys general in the Court of International Trade as well as the U.S. District Court for D.C. The Court of International Trade held unanimously that the tariffs were illegal, that the president does not have the authority under IEEPA, as he claims, to impose these tariffs. That decision is currently on appeal, and while it's on appeal, the tariffs continue to be collected. Whatever the decision may be on appeal through the Court of Appeals for the Federal Circuit, we are quite certain that it'll eventually be decided at the level of the Supreme Court. So going on from IEEPA, so IEEPA was a new tariff authority that President Trump leaned into for the two sets of tariffs, the fentanyl and reciprocal. Next, you have the Section 232 tariffs under the Trade Expansion Act of 1962. As I mentioned, these tariffs were imposed in the first Trump term on imports of steel and aluminum. Initially, when the tariffs were imposed in 2018, steel was subject to a rate of 25%, and aluminum was subject to a rate of 10%. At some point, a limited number of countries got exclusions or exemptions. For instance, Canada and Mexico were excluded from the tariffs, and some other countries either were subject to quotas or tariff rate quotas, such as Australia, Brazil, South Korea, UK, EU as well. And they operated under that limited exclusion where they could send the steel or aluminum up to a certain quota quantity, and if they exceeded that quota quantity, they would then be subject to the tariffs. And the Biden administration, as I mentioned, did not adjust that mechanism. That continued. In his second term, President Trump has expanded on the Section 232 tariffs. Specifically, the tariffs on aluminum were raised from 10% to 25%. And all of the exclusions and the tariff rate quotas or the quotas were removed, and which means that countries previously like Canada, Mexico, or Argentina, Brazil that were not subject to the 232 tariffs now became subject to the Section 232 tariffs on steel and aluminum. Further, the rate of 25% was further increased to 50% starting June 4th. As I mentioned, the United States and the UK have an agreement that they've reached on how to further their trading relationship. And as a result of that agreement, the United States has a Section 232 rate of 25%, as opposed to everyone else that is now subject to 50% tariff rate. In addition to the tariffs on primary steel or aluminum products, the Section 232 tariffs also cover something called derivative articles. These are articles that are downstream articles that incorporate a certain amount of steel or aluminum content. Now, so you not only have to pay tariffs on primary articles of steel and aluminum, but a number of other articles that you wouldn't normally consider as steel or aluminum, but those that contain a certain amount of steel or aluminum are also now subject to the tariff. President Trump has also relied on Section 232 to impose tariffs on autos and auto parts, again, under the same statute. And the tariffs are imposed at 25%. And those went into effect on April 3rd and May 3rd for the auto parts. Finally, you have the Section 301 tariffs. So the 301 tariffs were imposed by President Trump in 2018. They were imposed on China. They focused on China, and the idea was to punish China for its theft of U.S. intellectual property and know-how. And the idea was that the imposition of tariffs would cause China to amend its ways and protect intellectual property. The tariffs were imposed in 4 rounds. So you had the first, or they call the lists. So the first list was imposed tariffs of 25% starting July 2018. A second list imposed, again, 25% tariffs starting August 2018. And in September of 2018, a third list imposed tariffs on a number of other items from China. In 2019, there was a fourth list which imposed tariffs at 7.5%. This was in recognition at that time of an agreement that the United States and China reached. It's called the Phase 1 agreement, where China had agreed to purchase a number of agricultural products. And in recognition of China's commitment, the tariffs under the fourth list were kept at 7.5%. So as I mentioned, although these tariffs were imposed in the first Trump term, the Biden administration did not, scale back these tariffs. In fact, the tariffs were required to undergo a 4-year statutory review that was undertaken in the Biden administration. And as part of that review, that administration actually expanded these tariffs to a number of new items. All along, there were certain processes for claiming exclusions from the tariffs, but they were all time-bound and they expired at a certain time. There is a small group of products that are currently subject to exclusions. The exclusions were supposed to expire on May 31st of this year, but they've now been extended until August. But that's a very small subset of products. So given all of these different tariffs, how do they play out? How are they all stacking? Are they cumulative? Do you have to pay all of them? How does that work? So the administration has come out with some guidance, which we refer to as the stacking guidance, to help importers understand what duties are owed. So for instance, if your product is subject to Section 232 tariffs on steel and aluminum, they're not subject to the IEEPA Canada or Mexico fentanyl tariffs. If your item is a product which is listed on both the steel and aluminum lists, unfortunately, you have to pay tariffs under both of those lists. If you have a derivative product which has a certain amount of steel or aluminum content, then you pay the Section 232 tariffs on the steel or the aluminum content, but the non-steel or aluminum content is then subject to the 10% IEEPA reciprocal tariffs. So it's all very confusing, and it requires you to really understand where your product is coming from to determine if there are particular arrangements like the Canada-Mexico USMCA arrangement that might apply if they're coming in from Canada, Mexico, or not, and to then finally determine what the duty liability will be. So here is a table which kind of explains how these duties might affect products that are of relevance to the cannabis industry. So here you have 3 tariff subheadings. So the first one is 8543400040, which is the tariff subheading relevant for imports of electronic vaporizer kits. And as you can see, the tariffs differ depending on where you're importing the product from. So if your product is coming from China, you pay the normal 2.6% duty rate. That duty rate is applicable to all countries that trade with the United States, so whether it's China, EU, or Mexico. But if you're China, there are a host of other tariffs that are applicable. So you first pay the 10% IEEPA reciprocal tariffs. You also pay the 20% IEEPA fentanyl tariffs. And then, because this particular subheading is also on list 2 of the Section 301 tariffs, you pay an additional 25%, which brings the duty burden to 57.6% for this item. On the other hand, if you're importing this from the EU, you would pay a 10% IEEPA reciprocal tariff, along with the 2.6% normal duty, bringing your total duty burden to 12.6%. If you're importing these items from Mexico, but they don't qualify under the USMCA, you would pay the 25% IEEPA fentanyl tariffs, bringing the total duty burden to 27.6%. Now, if you're importing parts such as quartz insert, carb caps, or glass attachments, those would be imported under the tariff heading 8543908860. And that's an interesting subheading because the normal duty rate for that is free, meaning if none of these tariffs are applicable, you could bring in these parts without paying any duties. But now that you have, all of these different tariffs at play, this is how they would stack up. So if you were bringing them from China, you would pay the 10% IEEPA reciprocal, the 20% IEEPA fentanyl. And again, because this subheading is listed on the Section 301 tariffs list under list 3, you would pay the 25% tariffs on that as well. And so bringing the total duty burden to 55%. On the other hand, for EU and Mexico, you would only pay the IEEPA reciprocal for EU at 10%, and for Mexico, if it does not qualify under the USMCA, the 25% tariff for fentanyl. If you were importing smoking pipes, bongs, etc., under subheading 961400, that subheading has a compound duty structure, meaning there is an ad valorem rate as well as a specific rate. So the ad valorem rate for the different subheading ranges from between 3 to 7%, and there's a specific duty rate of 3 cents on each item. So if you were importing these goods from China, your duty burden would be between 40.5 to 44%, because you would have the IEEPA reciprocal, the fentanyl, as well as the Section 301 duty stacking. Here, interestingly, the Section 301 duties are not 25%, but they're 7.5%, because this particular subheading is on list 4. If you recall, I mentioned that list 4 had items which, in recognition of the initial China-US trade agreement, capped the tariffs at 7.5%. So with that, you have your tariffs ranging between 40 to 45%. On the other hand, if you were importing these from EU, your tariff burden would be between 13 and 17%. And if you were importing them from Mexico and did not qualify for USMCA, the tariff burden would be between 28 and 32%. So what this, I think, really highlights for importers is to be very clear on the country of origin for your item. Where are the products being manufactured? What are your classifications? Are you classifying it correctly to determine whether, the exact duty rate for your product? Because as you can see, the tariffs stack, and you could end up paying over 40% in tariffs, depending on how you classify the goods. And I will caution importers that a number of, a number of businesses might be tempted to change the classification of country of origin. And we hear that frequently from our clients that want to do that, and that's not necessarily illegal unless you seek an opinion from an expert that confirms that what you're trying to do is valid, and that your manufacturing processes actually allow you to claim a different country of origin. So, for instance, if you wanted to change it from, manufacturing from China to Vietnam or to the EU, we would advise that you get an opinion from an expert that would confirm that you can actually do that. So with that, let me stop it here and then turn it back to our audience to see if they have any questions.
We don't have any audience questions yet, but I have some questions. And I want to go back to just generally the definition of drug paraphernalia. I know we had a slide that states what the statute says, and it's quite broad, but can either one of you just give some real world examples of drug paraphernalia for maybe some newer practitioners that we have on that are not in the cannabis space? They may not actually know what it is as an example.
Sure, let me take that one, Hillary. So first of all, you're raising a really great point, because drug paraphernalia is defined very, very broadly, okay? As you made the point right at the top of the webinar, we are not talking about the actual marijuana, okay? We're talking about something that is used to process or to manufacture it or to use it in some way, shape, or form. If you go back to the 2 court cases we talked about, in one of those court cases, it was actual machinery that separated the different parts of the plant. In another one of the court cases, once again, it was machinery. So, of course, drug paraphernalia includes things like smoking pipes, bongs, vaping devices, certainly. But it really goes it's really much broader than that, and goes to anything involved in using or manipulating or processing the cannabis.
And when CBP is making a determination about what exactly drug paraphernalia is, I think I saw on one of your slides, Bob, that they will look at its primary intended use, its design, things like that. What if I'm importing vaping devices or pipes, and clearly they can be used for both tobacco and illegal controlled substances? How do you think that breaks?
Well, I think that in that case, Customs is going to err on the side of being conservative, okay? And that's actually, it's not just what I think, that's our actual experience, where we've seen goods actually even coming into Long Beach, the largest port in the United States, in California, which has a statute permitting people to possess, to distribute, to manufacture cannabis products. And Customs has still detained and in certain instances seized those goods. And that goes to the point that we made, that if you have that experience, then you have the ability to respond to customs with the detention or even at the seizure point, and point out the customs not just that there's an exemption under 863F, but also to cite very specifically the statutory provision, okay, that you believe applies to your product, and to make sure that that goes back to the detaining officer or to fines and penalties at the port. And our experience is that as long as it's laid out clearly, then it might take a couple of months, but customs will ultimately release the goods for importation.
And in making the determination about intent and the type of classification for the product, does customs actually look at how the importer record advertises, markets, what it's saying online about the product? Do they do that kind of outside diligence?
Absolutely, they do. And we have definitely had a number of instances, and actually it was more common, I would say, prior to the two court cases, the Kierton and Tariffs Technologies cases, where customs would actually go to the importer's website, then they would look at information on the website. I'm thinking of one instance in particular where a company brought in certain kinds of wooden boxes used to store the merchandise, and customs pointed out that those boxes had a marijuana leaf on them, and that the logo of the company also had a marijuana leaf and had some sort of indirect reference to cannabis, and they used that as support to seize the goods.
And Maushami, for you, can you give us an example of what might be the most expensive piece of drug paraphernalia to import to the United States based on those charts? Or is that just an unfair question because you need more facts?
Right. I think we do need more facts, but I think if you were, for instance, just looking at these three items between the electronic vaporizer kit and, the pipes, right? Depending on, for instance, with the pipes, depending on the type of pipe that you're bringing, whether it's a clay pipe, it's a glass pipe, you could end up paying tariffs about 3%, closer to 7%, right? And for the kit, you're paying like 2.6%, which is kind of average across, the different tariff lines in the tariff code. So it really depends on the kind of product and what it's made, because the tariffs are very specific, and usually can also depend on the material composition of the product.
Got it. And I've always wondered this because I am not a trade lawyer and I don't deal in tariffs. I'm more on the corporate, transactional, regulatory side in the cannabis industry. These countries of origin, China, Mexico, where a lot of these components are manufactured and compiled, do either one of you know in those home countries whether they take exception to the export because it violates U.S. drug laws? Let's say if it's intended to be used as a vape pen, an atomizer, that violates our drug paraphernalia laws. Do we know that?
That's a great question, Hillary. Certainly China does not, because we see a lot of this merchandise coming in from China. And also we've seen the larger machinery coming in from Mexico. So I guess the short answer would be that particularly with respect to cannabis, no, we do not. If you were talking about other sorts of drugs, I think it might be a different answer.
Got it. And I saw also in the slides, and I think for people who are not in this particular practice area, trying to get some guidance from essentially the regulator before you do any of these things. If you want to get a customs ruling on a country of origin question or a tariffs issue, what's the procedure, and generally how long does it take? And are there different kinds of preliminary evaluations you can ask for?
So yeah, I'll take that. So, well, yes, I think before you decide to make a ruling or request a ruling from customs, I think you should undertake a preliminary evaluation to see exactly where your manufacturing is taking place and what your country of origin is. We do that frequently for our clients, where we review what they're doing in the different countries and what they're proposing to shift to a different country. So if they're planning to shift from China to Vietnam or Thailand, we review the extent of manufacturing that is proposed to be undertaken in the new country to see whether it would meet customs standard for something called substantial transformation, which is what customs looks at to see whether the country of origin changes, right? Similarly, if the client believes that there is a different classification that applies to their product, then we would first review that with them to see whether under existing customs rules, that new classification makes sense, because there is a host of rulings that customs publishes on its website. And that is something that the importer is required to do. It's required to exercise reasonable care before classifying its products. So we help our clients review that to see whether their new classification would actually pass muster if customs were to have a look at this. So, and once we are confirmed and aligned with the client, we would prepare a package, including make a case for our client on why either the country of origin should change or the classification should change. And so this is the ruling request, which goes with a number of exhibits and information to allow customs to review the information on the record and say, yes, we agree with you that this needs to change or not. And customs can come back and ask for additional questions. But it generally takes between 30 to 45 days to customs to issue that ruling. Bob, I don't know if you wanted to add.
Sure. The only thing that I would add to that, a couple of points. If you're looking for a customs ruling on country of origin or tariff classification, absolutely. Customs tries to get you an answer within 30 days, although a number of times they'll come back with questions on, they'll get very granular on the product and ask for information, in which case you sort of get kicked out of line. And when you resubmit the information, the 30-day clock starts again. Those rulings come from the national import specialists, and you can submit that. There's a special module on the customs website, www.cbp.gov, that you can submit your ruling request. As opposed to a ruling request on country of origin or tariff classification, if you're looking for a ruling request on admissibility, and you'll remember we put up in one of our slides that customs is encouraging importers to get admissibility rulings depending upon the state where the merchandise comes in, or any other questions on whether the goods are actually allowed into the United States. That kind of a ruling goes to customs headquarters. And our information is that customs headquarters can be taking anywhere from 6 months to a year, possibly even longer, to issue an admissibility ruling. If you're going to go for an admissibility ruling, the company definitely needs to make sure that they provide full information on the product. And full information means that you should have a flow chart showing the different components that are being manufactured and where it's being manufactured. You absolutely have to identify the exact local, state, or federal law that authorizes the importation. And you should provide as well the anticipated port or ports where the goods will be coming in.
And are those rulings binding once they come out?
Yes. So that's a really good point. So first of all, the rulings are public, all right? And they're published on the customs website. Once again, www.cbp.gov, and it's under what they call the CROSS module, CROSS, Customs Rulings Online Search. I apologize, I forget the last S. But the point is that anybody can access those rulings and review those rulings. And that's a really good thing to do in advance of importing, because those rulings, and as you can see from a number of the slides we put up here, they can provide a roadmap as to what is needed, to what customs is going to be looking for. They can identify issues that you know that you're going to need to cover. In terms of, are they binding? Yes, those rulings are binding. But more, or I'd say equally importantly, Malsham mentioned that there's a statutory requirement for importers to exercise what they call reasonable care, okay? And reasonable care, there's actually a very good informed compliance publication on the customs website on what reasonable care means. And they basically say, well, it doesn't have just one meaning or one definition. And they say that reasonable care encompasses a a much broader range of activities, one, of course, of which is getting a customs ruling in advance. And if you have that customs ruling will suffice unless it's been revoked or something along those lines. In addition to get a customs ruling, any company wanting to exercise reasonable care in advance of importation, they can go to what customs would consider an expert. An expert would mean your customs broker, a customs consultant, a customs attorney, okay, anybody along those lines. If you reach out informally to customs, in certain instances, they'll have informal, non-binding conversations with you, but that is also helpful. Looking at rulings, looking at court cases, all of those things are important, and they all evidence reasonable care. And it's also important to note that, you know, what's the worst case here? Well, the worst case is not necessarily that you're going to get detained and maybe you can re-export them, that there are penalties involved. There's seizures, there's penalties involved. There are customs audits that can happen, you know, so all of those kinds of things. And you could be audited, for example, not necessarily on whether the goods were admissible, but basically on whether the machinery or the if it's the vaping device, on the tariff classification or the country of origin, or if you claimed that it qualified for a free trade agreement. So there's any number of enforcement actions that customs can take other than simply detaining and excluding the goods.
And are those rulings appealable? And if they are, is it even worth it to try?
That's a very interesting question. The answer is yes, they are appealable, okay? And they're appealable in a few different ways, all right? First of all, you can appeal a customs ruling administratively just by providing customs with additional information that shows customs that for one reason or another, the original ruling, it was based on incomplete facts or facts that were not correct, or that there's been some change in the law. And I guess we put up rulings in this webinar showing that customs has changed. The customs rulings have changed before the Tariffs and Kirtan cases and after, okay? A second way you can appeal a customs ruling is, frankly, to take it to court. The United States Court of International Trade. It's an Article 3 court, a federal court with a fancy name, but basically it used to be called the Customs Court. Now it's the Court of International Trade. And they hear tariff classification cases all the time. And the two cases actually that we discussed today were CIT, Court of International Trade cases. So yes, there are opportunities administratively and through litigation to do that.
And I would add that suppose you don't seek a ruling, but you've done your homework, right? You've looked at the rulings, you've looked at cross, and you've sought guidance, and you've decided that your product needs to be classified in a particular classification, or the country of origin is, you know, something other than China, and you bring the good in. And then customs decides to seek additional information from something called CF28, and then disagrees with your classification or country of origin, says, no, actually, this is the wrong classification. It should be classified under a different heading or subheading, which has a higher duty impact, right? And then it rate advances your entry. In that case, you have the ability to protest that decision by customs. And customs then looks at that decision again and decides whether what was done was accurate or not. And if customs, you know, denies the protest, meaning that they stay with that decision to, for instance, you know, rate advance your duties, collect additional tariffs, then you can appeal that to the CIT, the Court of International Trade. And so there are multiple ways in which, you know, if you disagree with customs' classification or decision on your products, those can be appealed.
Now, this might be a silly question, but I'm curious. Do either one of you know what customs does with this illegal drug paraphernalia if they actually seize it? Because it is illegal, so there's no resale market, I assume.
So they do one of two things. and it's not, and it's both common sense. All right. For certain kinds of merchandise, they will destroy it. Mm. Okay. I've seen not drug paraphernalia, but other prohibited merchandise destroyed, and it was really as simple as they put it in a crusher, and it all got crushed up. Okay. In a number of instances, customs will permit the company to re-export the goods. Okay. And in other instances, if they seize the goods, there are customs auctions. But if you're talking about prohibited goods, I think the difference would be if you're talking about prohibited goods, I don't think that they would auction off prohibited goods. I think that your best case scenario would be getting them to permit you to re-export the goods, and if not that, then they would just seize it and destroy it. You know, it's interesting also, by the way, that everything we're talking about is the downside, but you know, what can go wrong. We would just also point out, by the way, and I think that this goes to Malshami's chart in particular, showing the different rates of duties that apply. There are provisions, or there's logistic structures that people use to properly reduce the dutiable value of the goods in one way, shape, or form. First sale for export, some people are familiar with that, the use of buying agents, whatnot. So if companies are faced with extremely high duties, then they should be aware that there are those opportunities as well. But everything that Malshami mentioned and that we talked about in terms of getting a ruling and exercising reasonable care, that if you're looking at duty saving strategies, they certainly apply in those instances as well.
And in the last 3 minutes that we have the two of you, before I wrap it up, I'll ask each of you the same question. Feel free to answer or kind of pass if there's just no answer. But for both of you, what's the #1 mistake that you've seen drug paraphernalia importers make that is rectifiable?
Do you want to?
I'll let Malshami go first.
I mean, I would say, not so much from my experience, but I would think that assuming that a product is not, you know, comes under the term drug paraphernalia because it doesn't conform to, you know, popular notions of what is drug paraphernalia is probably the biggest mistake that you can make. So I think going to an expert, confirming what product it is, why it is being imported, for what use, I think is the first good step. And I think the second mistake that we see clients make across all industries is assuming that they know what the classification of the product is by just looking at the tariff code. And that's an extremely, I would say it's extremely technical exercise, which involves a very particular scheme of how you classify things. And so that, again, that is something that you must undertake with the assistance of an expert and not try to do individually.
On my side, I think I'm going to reiterate the first point that Malshami made, okay, which is if you're bringing in the goods and you know that these goods are drug paraphernalia, okay, and usually that shouldn't be a difficult question. Really, companies should be doing their due diligence in advance, and they should make sure that they understand why the goods can be admitted, why the 863F exemption applies. They should have that written up, and they should be prepared to submit that to customs in the event that customs detains or seizes the goods. Even if customs seizes the goods, our actual experience is that you can still get the goods released, okay? But it's certainly easier to do when they're merely detained as opposed to seized. And if you get a notice of proposed action, the Form 29 or Form 28 that Malshami mentioned, okay, even at that point in the administrative process, you should have your information as to why these goods are admissible ready to go. So that would be, and that's our actual experience, that the sooner you get in the administrative procedure and provide that, the better your chances are of getting your goods released.
Okay, Maushami, Bob, thank you. We are at the hour. And to everybody else, thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, before you go, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you.
Thank you.
Thank you.